It's effectively the use of technology, which generally we all call cookies, which track your activities when you're on a website and basically follow where you go and which pages you click through, with the intention of building up a profile on what you like and what you look at. To be honest, personal data from an online perspective is exactly the same as it would be in the offline world. The English or the UK Data Protection Act 1998 defines personal data as information which identifies a living individual, or data together with other data that would be reasonably expected to be in the possession of the data controller identifies a living individual, and it can be either electronic or it can be manual. Well, on the basis that it's a fundamental principle of data protection law that an individual must have consented to data being collected about them, the problem that OBA, or online behavioural advertising practices, have is that generally the use of cookies, for example, or other tracking devices occurs without an individual actually knowing that it happens. And so from that moment on, the first principle of the Data Protection Act is infringed, because there's no fair and lawful consent to the data that's being collected. So any business that is using their website or other online communication services to track individuals needs to put in place compliance with the Data Protection Act, which would probably mean considering whether they have to notify with the Information Commissioner's Office, which most businesses usually do, and then implementing a privacy policy or a fair processing statement that basically says up front, we respect your privacy, these are the things that we are going to do with your personal data, these are your rights, and these are the policies and procedures that we put in place to ensure that your data is kept secure. Well, the data controller is defined as the individual or business that makes decisions in relation to your personal data. And so on the face of it, what we call a first-party online behavioural advertising entity, that's the website, would be the data controller. So your business that is using a website and using cookies will be the data controller. But then it gets a bit more complicated than that, because if you use click-through advertising on your website, then the chances are that the individual's data is being collected once they click through and then head off to a third-party site. So that's to the third-party OBA provider. Or you may use Google Analytics, for example, to track what's happening on the website and where people are going and what's the most viewed page. And again, to the extent that Google then uses the data that they access, again, that makes them a data controller as well as you. Well, the new cookie law came into force on the 26th of May this year, 2011, and it effectively says that you must obtain consent from individuals before you set a cookie on a website. That's quite a challenge, because usually the moment that you access a website and hit the homepage, a cookie is usually set. In other words, one that realizes you have arrived, so to speak. So it's almost impossible for a data controller or a website owner to gain this prior consent that the new law has laid down, although the Information Commissioner's Office published guidance recently, as well as the government, that said nothing in the new law means that consent has to be prior, so it could be obtained at the time of or as soon as possible after you effectively have set a cookie running. So it does affect every business that is doing online behavioural advertising. Yes, the law says that if a cookie is absolutely essential to the technical performance of the website as a result of the request from the user, then you don't need to obtain consent. But it's very narrowly defined. So simply because you feel that it's useful to have a cookie running as part of your service doesn't mean that it's absolutely essential for the performance of the website with a particular user. So take it from me, there's not a lot of exceptions you could use. So does consent need to be prior, or do you have to have opted in before a cookie is used? The guidance from the UK government is that consent does not have to be prior. It has to be informed, or it has to be meaningful. So you've got to have told an individual what cookies you'll be using on the website, which means that you've got to push them towards your cookie statement or your privacy policy. And you have to flag up as early as possible the fact that you are using cookies, and then you can't get cookie consent by default. There has to be some positive action to signify that consent is given. So it might be a tick box, it might be as a result of a pop-up where you click accept, some sort of device like that. But the challenge for a lot of complex interactive websites is that they use not 1 or 5 or 10, but 20 or 30 cookies at any one time on the website in different parts. And the thought of trying to get consent for every occasion that a cookie is being set would actually deter a user from the experience that they want. So it's a real challenge. So the cookie law that came into the UK on the 26th of May 2011 says that you must have put in place a procedure whereby you obtain consent to the use of cookies being set. In order to do that, the guidance from the Information Commissioner's Office is that you need to audit your website to actually understand what cookies are being used. Most business people, unless they've got an immense technical background, wouldn't know the various cookies that are being used, from session cookies, which can be temporary as well as permanent, as well as tracking cookies, as well as security cookies, and a variety of other flash cookies. So you need to carry out an audit to find out what cookies do we use. And then once you know what you're using, you're in a better position to draft up a cookie consent procedure whereby you actually tell people, this is what we do with cookies, this is how we protect your rights, and so you need to define those in the cookie statement. The Information Commissioner's Office on the 25th of May of 2011 published guidance that said even though the law comes in on the 26th, we think you've got a year in which you can get your so-called act together, and we won't necessarily be enforcing against non-compliant companies on the 27th of May. But doing nothing is no defence whatsoever. So I'd advocate companies should be auditing the websites to find out what cookies they've got, then looking at redefining their cookie statement or privacy policy, and then also working out what's the most effective way to gain consent without damaging the user experience.